final case that is set to be heard this morning is case number somewhere here. Let's see. Yes, case number 17AP0039, Jeffrey Daso et al. Versus Creston Insurance Center, LLC. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes if you would like for rebuttal. The arguments are being recorded, so keep your voice up and try to stay by the podium. We've read the briefs and are ready to proceed when you are.
Thank you, Your Honor.
Sure.
May it please the court. Kenneth Fisher, attorney for appellant Jeffrey Daso and Daso Custom Cabinetry, LLC. The issue before this honorable court this morning is the interpretation and application of Ohio Revised Code section 3929.25.
All right, before you get into that, do you want to reserve time?
I'm sorry, I'd like to reserve 5 minutes.
5 minutes,
Thank
okay.
you.
Sorry to interrupt you.
No. Thank you. Yes, I'd like to reserve 5 minutes. Thank you.
Thanks.
The application of 3929.25, again, and the requirements in action by an insured against the insurance agent, requirements of 3929.25 require that the agent inspect, describe, and fix the insurable value of the property to be insured prior to the time that the policy is issued. The facts in this case clearly state that the insurance agent, Brenda Rose, Creston Insurance Center, LLC, at no point in time from the beginning of the relationship between Creston and Daso in 2005 all the way through 2014, at no point in time inspected, described, and fixed the insurable value of the property, in this case, the cabinetry structure business located in Creston on East Salem Road. The facts are, Your Honors, that in 2004, prior to the commencement of the relationship between Creston Insurance, Brenda Rose, and Jeffrey Daso, there was a fire. The payments were made, policy canceled, at which point the relationship commenced after Daso rebuilt his structure, his cabinetry business structure. The relationship commenced, and Brenda Rose testified clearly at deposition that beginning then, when the policy with Mennonite was issued by and through her as the agent, all the way through 2014 when Mennonite canceled the policy because they made a business decision because of the high risk cabinetry, wood, adhesives. They weren't going to insure cabinet businesses anymore. New policy was issued with motorists, which is really the subject of the lawsuit. The limits in the policy were $200,000 for property, $100,000 for inventory, but at no point did Brenda Rose do what 3929.25 requires, and that is inspect, describe, and fix the insurable value, which again would allow the insured to make an intelligent decision on the amount of coverage that's required in order to replace the structure.
So then are we only talking about damages suffered related to the structure? Because of what import would be an assessment of the value of the inventory at the time prior to if the damage occurred and the inventory was different?
Your Honor, agreed. Yes, that's true. So the policy itself, 200, there was an inflation factor. It went up to 208,000, but the losses documented by motorists was 1.3 million. So there's a substantial difference, again, in the amount of the coverage and the loss sustained in August of 2015 when unfortunately a fire occurred and the entire structure was destroyed. So there's a substantial difference, again, between the policy limits that were, contracted for and the amount of the loss. And again, it's the position of the appellant that, at least in part, the negligence of the insurance agent resulted in coverage being wholly insufficient. This court, again, has looked at this case, this issue, I should say, excuse me, Warwick versus Nationwide Insurance Company, 2007 reported case that's been briefed extensively. And this court, again, specifically stated, contrary to the 6th Appellate District in Munn versus Stapleton, specifically overruled Munn versus Rudy Stapleton reported case and said that 3929.25 does apply in a negligence action against an insurance agent.
All
And
right.
that,
Hang on,
sorry,
that's negligence. You're arguing negligence per se.
yes. Negligence per se, or on the alternative negligence, there's the counts are there. So if the court believes that, again, the
Okay, then
statute applies.
Let's back up. The counts are there, but what did you argue in your brief?
We argue negligence per se.
And that's what we're talking about up here.
Okay, I understand.
But Horak didn't discuss negligence per se. I agree with you that Horak says, no, we don't agree with Munn. Trial court relied on Munn. Horak said, we don't agree with Munn, but Horak did not address negligence per se.
In our reply brief, that's true, Your Honor, and I understand that that is obviously a separate issue from Horak. However, in our reply brief, we did in fact contend that if in fact the court would determine in the alternative that the statute applies, and again, His Honor, the trial judge, determined based upon, and he specifically cites Munn versus Rudy Stapleton, that 3929.25 doesn't apply, which we take exception to, respectfully, that again, if it isn't negligence per se, we argue that it would be comparative negligence, again, citing Jones versus Auto Owners Mutual Insurance Company, that the analysis would be based on comparative negligence. For example,
In your reply brief?
we do cite it, and I believe in the briefing sheet too, but I know in the reply brief. I mean, again, there's negligence that's being pled. The issue, again, we believe, and we did clearly state that under 3929.25, it is negligence per se, that it is a statute as a matter of public policy and safety that, again, should be interpreted as negligence per se. But in the alternative, minimally, it's a comparative negligence analysis, which means summary judgment should not have been granted. The application itself is in question. The insurance application filled out by Brenda Rhodes by her own admission in 2014, prior to the time the motorist policy was issued. She testified, again, that at no point did she ever inspect the property, visit the property, determine the insurable value of the property. So there's no question about that. In terms of the application itself, it's her handwriting. She testified at deposition. She filled it out. Mr. Daso testified, the appellant, okay, that he signed it, he remembers signing it, but he did not believe he saw the whole application. Okay. I understand there's some responsibility on the part of the insured. We're not trying to shirk it. Yeah, but at the same time, again, it's the application of the statute and the fact that an informed decision clearly wasn't made, and the property itself was significantly, by over $1 million, underinsured. So that, again, is a very, I think, major point here. Jeffrey Daso is a cabinet maker with a high school education. He is not sophisticated, perhaps as much as the appellees have done a job of saying, oh, he relied on this, he did that. He's a cabinet maker that employs perhaps 10 people that's worked hard to build a business. That's his expertise, but he's not an MBA.
Well, he knew how much he paid for the added additions to his building, yes?
Correct.
So he knew the extra value.
He knew there was extra value.
You don't need to be a PhD to know that.
Agreed, but he didn't know the replacement value. And it wasn't until motorists came in and adjusted the loss and did the analysis, the analysis on the cost estimator for the replacement value. It wasn't done until after the fact that he knew that he was underinsured by over $1 million. And that to me, again, is reason enough for this court to overturn the trial court's decision granting a summary judgment, saying that that reasonable minds can only come to one conclusion: significantly underinsured and non-compliance by admission, complete non-compliance. So unlike Horak, where the decision, the Horrocks, similar case, it was $100,000, it was a fire in a house. There was $100,000 less coverage than required to rebuild the house. The Horrocks filed the action against Nationwide and the agents, and the court determined, the Horrocks court, this Ninth Appellate District, that there wasn't sufficient evidence to show that the inspection at some point hadn't been made, that the insurable value hadn't been previously determined. And mentioned the first agent was App.No, the second agent was Timothy Crawford in Horrocks, and there was no evidence what Nettle would have done. And again, the Jones case stands for the proposition, Jones versus Auto Owners Mutual Insurance Company, cited with approval in Horrocks, that you don't have to make annual inspections. So what's the responsibility that the insurance agent has?
I just want to let you know you're at 4 minutes, 51 seconds. So if you want to continue, that's fine, but you're into your rebuttal.
Thank you, Your Honor.
Okay.
So in essence then, the responsibility is not an annual, it's to do it, at least initially. And it's clear, from 2005, when the first policy was issued with Mennonite, all the way through 2014, at no point did Brenda Rhodes, the agent for Creston Insurance Center LLC, do anything in terms of measurements, inspection, fixed insurable value, and again, also testified that it wasn't until recently, after the fire, that commercial carriers that she is an agent for made this requirement. She says presently that's the requirement, and she testified at deposition she's not going to be writing commercial insurance anymore because she doesn't want to do the inspections and determine the insurable value. Thank you.
All right, you have 4 minutes, 4 seconds left, Mr. Fisher, for your rebuttal.
May it please the court, my name is Frank Scaldone and I represent Creston Insurance Center and Brenda Rhodes. My understanding is the plaintiff has, on appeal, has limited his case. The case is not about a fiduciary relationship because this is just a typical business relationship in Ohio. And it's not about even the common law duty between an agent and a customer. And the trial court properly found that Creston acted in good faith with diligence and granted summary judgment. With this case, I guess I should point out one thing, that the argument about contributory or comparative negligence is kind of news to me, and certainly the case law in Ohio and the appellate courts, you can't raise an argument for the first time in the reply. It's precluded. So that's not an issue in this case. What's an issue in this case is the doctrine of negligence per se and how Ohio's value policy statute applies to that. We begin with the Supreme Court's counsel that negligence per se is narrowly construed, and that's the Chambers case. And in fact, computer-assisted research shows that no case has ever imposed liability on an insurance agent through the value policy statute. So the requirements of negligence per se, the doctrine only applies when the purpose of the statute is to protect a class of people to which the plaintiff belongs from the risk of the type of injury plaintiff suffered. Now, the Ninth District has previously held what the legislative intent of that, correctly, the legislative intent of that act. In the Horrocks case, it states RC, quote, RC 392925, which is Ohio's value policy statute, which is referred to as the value policy statute, prevents insurers from over-insuring property in an attempt to collect increased premiums and then paying less than the policy limit if a building burns down and results in a total loss. So let's apply the facts to the law. Daso is not claiming that he was over-insured and damaged because he paid inflated insurance premiums. He's claiming that he was underinsured. So the purpose of the statute is not to give Daso coverage that he did not want at the time, but now does in light of the knowledge of the loss. He's not a member of the class of people that the Ohio statute was designed to protect. That's it, insureds that were overinsured. Now, it becomes even more clear when you look at the language of the value policy statute itself. Another proposition that's well established in Ohio is that negligence per se only applies if there is a violation of statute solely by the one whose duty it is to obey it. Now, the express, and that's the Supreme Court's decision in Hearst, the express text of the section places the duty of setting a value on the insurance company, not the agent. And the text is this, quote, a person, company, or association insuring any building or structure against loss or damage. That's who has the duty. The insurance agent does not, and again, it has never been held to be that, and it makes perfect sense. Because otherwise it would throw into flux all of the general, the duty that an Ohio insurance agent has to provide the coverage that the customer suggests.
Well, how would an insurance company do that if they weren't going to do it through their agent?
That's what I'm, not to be flippant, but it's kind of besides the point. They would go through an agent, and generally, like in the Horak case, in that case, very different. One of the main distinguishing factors of that is you had a captive agent. You had an agent who all he dealt with was nationwide policies. So I think the court probably, the statements in the footnote kind of came from a little bit more of the closer relationship between that agent and the insurance company.
Was Mr. Daso offered higher limits, more insurance than he purchased?
He was, and he actually turned it down because he was very cost conscious, and the stipulated facts, I think, even articulate this. One, there was a series of, I think, 5 years where he didn't have any insurance at all. When he did get offered insurance, he accepted a lower amount than was actually suggested by the agent. So some of the cases, you have the 6th district that I think correctly states that RC 392925 is applicable in a contractual dispute between an insured and his insurer. That makes perfect sense. It categorically rejected, that it would apply to a negligence action. And Judge Callahan, as you pointed out, we're, again, keeping the case focused. This is a negligence per se action. So we're applying the negligence per se principles to using this statute to impose liability like it has never been done before in Ohio. With regard to my opponent cites the Jones case, but that comes after this, and it's another 6th district case. That came after the 6th district's Munn case that expressly stated that the statute doesn't apply to a negligence action involving an agent. There's one other thing I wanted to point with the Horak case. It's interesting, when I was looking at the case, the judges didn't look familiar to me, and it was I thought maybe Westlaw made a mistake, but it was, they were visiting judges from the 5th district. And I think the way that can be squared, if it really needs to be squared, because it really didn't deal completely on point with what we're talking about here, is that the court ultimately granted summary judgment in favor of the agent because the customer, quote, was paid the full amount of their coverage. Thus, the purpose of RC 392925 was satisfied. So it's in accord with our theory of the case and with Ohio law. It doesn't apply the statute is there to protect people from being overinsured and preventing insurance companies from reaping the rewards of premiums that they're really not owed. If the court doesn't have any questions, I'll rest at this point and request that the court affirm the trial court's order granting summary judgment.
Did this agent inspect the property?
The record is...
what did she do that would comply with this statute?
Again, I'm not trying to be flippant because it's really relevant to our premise of this case. My understanding of the record is initially when coverage was purchased, she did some minimal inspections, and that's the extent of it.
Originally, when coverage was purchased, before this happened?
Before there was a policy that was, I forget the name of the company, but there was a a company that issued a policy, a newer policy, after the one had stopped providing insurance.
But there's no dispute that Motors was a new policy.
It was the continuation of the same types of coverage, so to that extent, but of course it's a new company issuing the policy.
Other questions? Anything else? All right, thank you very
Thank
much.
you very much. Appreciate your time.
Excuse me. Your Honors.
4 minutes
One
and
assignment.
4 seconds.
Thank you. I will also quickly. I know that's an oxymoron. Okay. Assignment of error. The Wayne County Court of Common Pleas Court erred in holding Ohio Revised Code Section 3929.25 is inapplicable to a negligent action brought by an insured against his insurance agent in granting defendant's appellee's motion for summary judgment and denying plaintiff appellant motion for summary judgment on liability only. That's the assignment of error. We also say on page 8 of our brief, Creston's complete failure to comply with the statutory duty imposed by Ohio Revised Code Section 3929.25 is negligence per se and/or a breach of the due care standard owed to Daso. As such, failure deprived Daso of the opportunity to make an informed decision relative to the amount of insurance coverage to be provided by motorists. The facts show that when the Mennonite policy was issued by and through Creston Insurance Company in 2005, there was no inspection, admitted by Brenda Rhodes. Further, when the new policy with motorists was issued in 2014, no inspection, no determination of insurable value. The insured is operating in a vacuum. Yes, he built the building, and with his own hands, okay? But again, he's not able to know what the replacement cost is. And the replacement cost was way beyond the amount of the coverage that was afforded. And at no point were the higher limits offered him, and it was a new policy. So I think it's incorrect to say that it's a continuation of an old policy. The Mennonite policy terminated. They made a determination not to continue to insure.
Counsel, throughout your brief, you use and bold out the word new policy, new policy, new policy. I could not find any case law on new policy. As a matter of fact, HORAC itself uses the term initial coverage. Now, you are also talking about the initial, what
Yes.
happened way back in 2004 here, but
Can I say HORAC, please?
go ahead.
Okay, HORAC. However, as noted by the court in Jones versus Owners Policy Mutual Insurance Code, it cites the site of the case, does create a duty on the part of an insurance agent to inspect the property, assign insurable value at the time coverage is initially sold to a property owner. Did not happen here. However, nothing in the provision creates an ongoing duty for the agent to make yearly inspections of the property to ensure the value is not changed. It never happened. That's the point, that it's a new policy, and unlike HORAC, where it was determined that App.No, the prior agent, may have, the record was devoid, made an inspection, set the insurable value for the HORACs earlier. The facts in this case are in opposite. At no point did Brenda Rhodes inspect the property, do the measurements, and establish the insurable value. So at all times, Jeffrey Daso was operating in a complete vacuum, uninformed of what the replacement cost would be. And that's a direct breach of 3929.25. And I think the assignment of error, again, is that that the court's ruling, especially its reliance, as stated in His Honor's order, that Munn versus Stapleton is controlling, is wrong. It's not controlling. This court has said as much in HORAC. And we're talking about a negligence action. That's the assignment of error. Yes, we talk negligence per se, but we also say that and/or. Clearly, right here in the brief in chief, breach of the due care standard owed to Daso. A failure to make an informed decision as to the amount of coverage. Thank you.
Perfect timing. Your time has just expired. Thank you both for your arguments today and your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you copies of the court's decision. They're also posted on the Supreme Court's website, so feel free to keep an eye on that website. Court is now adjourned until May 15th, when the court will be sitting in Lorraine County.